gentlemen. We are here to discuss something which is rather interesting and controversial. But before we get started on that, we'd just like to welcome our distinguished panelists with bouquets of flowers. So I'd request Mr. Vijay Malik to please present a bouquet to Mr. Nariman. Request Mr. Sumain Malik to present a bouquet to Mr. Andrayjuna, please. Mr. Sumit Malik to present a bouquet to Mr. Lalit Bhasin, please. I have the pleasure of presenting a bouquet to Dr. Swami. Request Mr. Raghunandan Malik to present a bouquet to Dr. Spedding, one of the authors of the book. Mr. Abhinandan Malik to present a bouquet to Ms. Taneja, ma'am, the author of the book. Mr. Vijay Malik again to present a bouquet to Ms. Akila Agarwal, and Mr. Sumain Malik to present a bouquet to Mr. Gautam Saha. I welcome each panelist. We are grateful that you've spared your time to be here, and we welcome each of you and thank you for sparing of your time to be here. And Mr. Sumain Malik will start with a slightly more formal welcome note. Mr. Malik.
Thank you, Sudeep. I welcome our chief guest, Mr. Nariman. Mr. Fali Nariman needs no introduction whatsoever. However, it's my duty to say a few things about him. He's an eminent jurist and a constitutional expert. He was a former member of the Rajya Sabha. And Mr. Andrayjuna is our guest of honor. Welcome, sir. Again, needs no introduction. He is a senior advocate at the Supreme Court of India. He was the former Solicitor General of India and the Advocate General of Maharashtra. Our guest of honor, Mr. Lalit Bhasin, is the president of the Society of Law Firms of India. He's been in practice more than 50 years and celebrated that recently. So welcome, Mr. Bhasin. Dr. Linda Spedding is an international expert in law. She first came to India in 1981 with the International Association of Young Lawyers and then the International Bar Association. She's had a very long association with India. She's been an advisor to corporate and public sector firms. And she has made a special contribution to the book and also written a foreword. Thank you for being here. The author, Ms. Ramni Taneja, is an advocate since 1980, practicing in the Supreme Court and the Delhi High Court. She's also been admitted as an English solicitor in the Supreme Court of England and Wales. She's also practiced in the Middle East. And so she's had a lot of international experience, which she brings to bear on this book. Welcome, Ms. Taneja. Our panelists, Ms. Akila Agarwal, partner in Amarchand Mangaldas. She's studied her law at National Law School, Bangalore. She's advised on many collaborations between Indian and foreign companies, and that is her specialization, I think.
Yes.
So welcome, and thank you for being here. Mr. Gautam Saha is partner in AZB, also studied at NLS Bangalore and at Oxford. Welcome, and thank you for being here. Dr. Swami. Dr. Swami has been an eminent economist and a former professor at Harvard, if I'm right. Has been closely associated with academics. Thank you, sir. You've been a former cabinet minister, held many ministerial posts, including the law ministry and industries.
without being a lawyer.
So I think for you this book will hold a special interest because these are both subjects very close to your heart. Thank you very much for being here and for gracing this occasion. Welcome, sir.
Before we move on, I think we should release the book. So I'd request Mr. Nariman to formally release the book. May I now request Mr. Nariman to share his thoughts on FDI and globalization with us. Mr. Nariman.
Thank you. Distinguished ladies and gentlemen on the panel and in the audience. There is a season for everything. December is a season for marriages, and it is also a season for book releases at the rate of at least 2 or 3 a week. Books are written for reading, some for light reading, others for serious reading. And the book which is just released today on foreign direct investment and globalization is heavy, not just in weight, but fortunately in content as well. Every aspect of foreign direct investment is covered with detailed information to the reader about all the press notes of the Government of India and about the latest circulars of the Reserve Bank. All in all, it is a mine of information on FDIs expressed simply and with lucidity. As the saying goes, he that runs may read. Its principal author, Ramni Taneja, is a friend of our family. But till I turned the pages of the book, I did not realize her expertise on FDI. Ramni is adept at concealing her talents. She's one of the most humble people I've met. I knew she had many attributes, but not this one. I knew that she was proficient in the French language, because when on rare occasions I receive something in French, of which I have only the most perfunctory acquaintance, I rely on her to give me an effective translation, and she always obliges, that too in record time. Foreign direct investment in India has received a stimulus. How much is a little doubtful, but it has received a considerable stimulus with bilateral investment promotion agreements, or BIPAs as they are called. And there are a range of about 80 different countries which have entered into such agreements with India. They are all set out in the book. BIPAs, as you know, promote investments through state-guaranteed foreign arbitration when dispute arise. To improve prospects of foreign investments, it was only in and from the 1990s that India expressed its willingness to enter into BITs or BIPAs. But these were documents skillfully crafted by smart lawyers in the developed countries. The BITs or BIPAs are an ingenious device invented by legal professionals in affluent states, designed more to protect foreign investments in the host states than to promote them. In fact, there is not a single BIT or BIPA I know of that has any causal link between the protection of investment in the host state with the quantum of investment by investors of the treaty state in the host state. We in India should protect foreign investments, but only if such protection is reciprocated by an assurance of large-scale investments in India by investors from that foreign state. An investor from state A with whom India has signed a BPA is entitled to take action under the BPA, even though he is not a party to any agreement with the government or a government entity in India. And this is called arbitration without privity, a novel idea invented, as I told you, by smart lawyers. India's experience with this hybrid form of arbitration has varied over the years, first from indifference to later much interest, then to euphoria, but finally to acute disappointment. The recent award of October 2011 of a foreign tribunal in the White Industries case is an instance of acute disappointment. The White Australia Award is mentioned in the book, but it needs more than mention. It requires study and comment and much closer attention by experts like Ramni Taneja, because the reasoning in the award, if treated as a precedent, which it is bound to be, will have adverse effects on India's financial economy. If I may make a concrete suggestion, since I am confident that this book will go into several editions, it is essential that there should be a critique of the award in the White Industries case in the next edition of this book, since the award has far-reaching consequences. In effect, the White Industries Award of October 2011 has initiated a dangerous precedent for India. If some of you do not know what it was, in short, it holds that if a foreign investor's claim in courts in India under a foreign award is unduly delayed, then that foreign investor is entitled to claim substantial sums in foreign currency as damages merely for delay in decision making by Indian courts. The award of 2011 has already set alarm bells ringing in North Block. The aftermath in the White Industries case has been quite catastrophic. This London award awarded to the Australian party almost 10 million Australian dollars in damages, interest and costs, all because of delay in a matter relating to a foreign award in favor of White Industry for 4 million Australian dollars, then pending and still pending in the Supreme Court of India. The Government of India was promptly paying up the entire amount in accordance with its existing international obligations, has now gone back into its shell and has decided it will no more enter into BIPs or BITs or BIPAs. The Government of India is also said to be exploring ways and means of putting in place interpretative clauses to its existing BIPAs, which is a practice common in countries that are parties to the North American Free Trade Agreement or NAFTA. Many other countries around the world are doing this as well, including South Africa and, surprise, surprise, Australia itself. Before the recent elections in Australia, in a government policy statement issued in April 2011, the government of Australia, that is the previous government of Australia, not the current one after the elections, has categorically asserted that it would not tolerate foreign companies attempting to restrict the Australian government's policy making, and it would no longer accept provisions in future BIP which allow such foreign companies to take direct action against states. The current disenchantment of India with BIPAs was preceded by a strongly worded public statement on the international investment regime, and it emanated from discussions by various professors around the world, academics who are not arbitrators, at a workshop meeting in Canada. This public statement, which was issued in the year 2010, long before the award in the White Industries case, was by nearly 50 professors of international law and economics. Their observations are not very flattering to the concept of bilateral investment treaties as we have come to know them. And the public statement records that investment treaty arbitration, as currently constituted, is not a fair, independent and balanced method for the resolution of investment disputes and therefore should not be relied on for this purpose. Second, that there is a strong moral as well as policy case for governments to withdraw from investment treaties and to oppose investor-state arbitration, including by refusing to pay arbitration awards made under them, where awards for compensation have followed, even from good faith measures introduced by the host state for a legitimate purpose. And third, the statement has expressed preferences for investment contracts rather than investment treaties as the legal mechanism to supplement domestic law in the regulation of investor-state relations because, as it mentions, they allow for greater care to be taken and greater certainty to be achieved in the framing of the parties' legal rights and obligations. So after November 2011, India's experience with BIPAs has run into extremely rough weather. And we will all need more of your expertise, Ramni Taneja, to undertake some critical comment, particularly about the most favored nation clauses in treaties, because that has been applied in the Australia case. Because there are many more cases in the pipeline, cases by foreign investors, where their claims under foreign awards have languished in Indian courts only because of the law's inevitable delays. Although delays in decision-making by courts in India are, under our law, to be compensated by the grant of interest on sums awarded, this circumstance has not been appreciated in the award in question, which, unless some measures are taken quickly and promptly, even before the next general election of 2014, we are likely to witness many more foreign awards like the one in the White Industries case, granting damages to foreign investors against the government of India in millions of dollars, not on the merits of the case, but only because of delays in decision-making by Indian courts and by the Supreme Court. A perceptive investigation into this and an article by the author of this fine book would greatly help not only the academic community and the business community, but the judiciary as well, which also, in the matter of delays in court verdicts, needs to pull up its socks. There has to be a fast track for dealing with cases under foreign awards. I had recommended this many, many years ago during the Chief Justiceship of Justice Anand from 1998 to 2001, but nothing has come of this suggestion for 12 years now. I'm very sorry to sound pessimistic this evening at a book release of this very fine work, but it is because of the excellence of the treatment otherwise given by the author to FDIs in India that I am emboldened to suggest to the author, whom I know well for her erudition and steadfastness of purpose, to explain to the Indian public and to the world sooner rather than later India's point of view as to whether the Indian state under India's constitution can at all be held liable for delays of civil proceedings in its courts. It is a juristic exercise that simply brooks no delay. With these rather disarming and unfortunate words, I must conclude this address with hearty congratulations to the author for bringing out a very fine work.
I have here so many distinguished people. My friend Fali is here. Dr. Linda Spedding, one of the biggest authorities on foreign direct investment here. We have Dr. Subramaniam Swamy, who I think is a quasi-lawyer by now. I see him every week in the Supreme Court. We have here also my friend Lalit Basin, and then we have also Mr. Malik and two very enterprising young students, Akela Agarwal and Gautam Saha. So it's a very lovely gathering here. May I say this at the outset, that this is really a pioneering book by Ramni Taneja. Nobody today, till today, has written a book on foreign direct investment and globalization in such a comprehensive way in which she has done. And my great compliments to her for this particular book. She asked me to write a foreword to it. I was quite unequal to that, but she pressed me for that, so I wrote a foreword expressing my admiration for her. The book is so topical today. With India's GDP used to be averaging to about 8.80% till recently, and foreign exchange reserves at over $2.73 billion, in a booming capital market, India has become a prime destination for FDI. There is also increasingly investments by Indian companies abroad, and Indian companies are listed on the international stock exchanges. Both aspects of foreign investment within and outside India are a matter of public policy and governmental regulation. It's an extremely complex subject. Ramni has presented a manual of the expounding the government policies from time to time and the regulatory framework in this complex subject. The FDI revolution, as she says it, has been principally due to the automatic route which the Reserve Bank of India regulations have now been introduced in 2012 and 11. Earlier, you required a lot of permission from the Reserve Bank of India for FDI, which restricted the flow of FDI, both in India and outside India. Now, today, the RBI regulations allow 100% in most sectors except certain restricted sectors for FDI. FDI flows from financial year 2012-13 for the month of December 2012 was 1.1 billion, and the equity flows for 2012-13 was $27.9 billion. From the year 2000 to 2012, equity inflows was about $187 billion. So this is the magnitude of the problem today. Now, globalization has its own adverse side also for developing countries like India. This is a fear of jobs being destroyed, culture being eroded, and poverty and instability. You can't get away from the fact. That is why FDI is such a controversial subject today. The common man, it is said, will not benefit by all this. And nobody wants here bags by Louis Vuitton or by Gucci because we can do without them. Now, this is a sort of thing which today is an opposition to the FDI. For this reason, there is so much opposition to Government of India's policies on FDI. And because in August 2013, the FDI was introduced in multi-brand retail trading as part of the circular which was issued at that time. There has been a tremendous and political and acrimonious debate on this. You remember actually Parliament was held up about a few sessions back on this particular subject, etc. And there is nothing, as certain political parties believe, that in FDI, in retail trade, can promote instability by exploiting, by the exploitive and corrupt ways of multinationals. Today, there is also a lot of controversy about the FDI in pharmaceuticals, etc. Ramni Taneja has dealt with these fears and apprehensions in her last chapter of this book. She has referred to the Supreme Court judgment in Manohar Lal Sharma's case, which was delivered only this year, and which this judgment holds, that the court will not interfere with the Government of India's conception of advantages from a FDI policy, which is only an enabling policy, leaving it to the state governments and the union territories to implement it. Now, Ramni Taneja has, if you look at the book, it's a masterly presentation of all the scattered political policies which were there earlier, the political papers which were there, and the regulations by the RBI, and acts of parliament and circulars, which are not easily accessible to the common man. The legal position pronounced by judgments of the Supreme Court and the High Courts are not easily available. Ramni has therefore combined all this in a manual which is really so comprehensive and easily be accessible to anybody today. That is why I think this book will see many, many editions. And I'm sure that as with each edition, it will improve itself. Ramni's book gives details of leading decisions of the High Courts and of the Supreme Court. For that alone, the book is an extremely valuable book. Besides Ramni's contribution to this book, you have an excellent expert treatise by Dr. Linda Spedding. And if you read that, you will appreciate the magnitude of this particular problem. Now, at the end of all this, I would say that Ramni has brought to bear on this book her vast academic learning. She was educated partly in UK. She was a UK solicitor. Then she came down to India. She was a solicitor assisting a leading solicitor in Little and Company. Then she was transferred herself to Delhi, where she has become a renowned person because of her industry and her learning. More than anything, you will also find that she is not just a mundane lawyer. She is also loves literature. In the book, you will find ample references to many, many parts of literature. She quotes Vivekananda, she quotes Mark Tully, etc. And it's really an excellent reading book, etc. And as Fali rightly pointed out, this lady is also distinguished in the French language. If you have any problems, legal problems for a French company or anything written in French, Ramni is always there to help. So with all that, may I congratulate Ramni for an extremely pioneering publication. I'm sure it'll do very well. And once again, my heartiest congratulations.